Hello and welcome to In Depth with me, Frank Pereira. The Office of the Chief Justice of India is in the news for a variety of reasons these days. In a recent ruling, the Supreme Court itself said the Chief Justice of India is the first among equals and has the constitutional authority to decide the allocation of cases and setting up of benches to hear them. The Supreme Court further ruled that since the CJI is a high constitutional functionary, that there can't be any distrust about the responsibilities he discharges to ensure that the Supreme Court carries out the work required under the Constitution. The ruling, in short, lays down the extent of the powers of the Chief Justice of India. But what exactly does he do? What is his role under the Constitution and his place in Indian judiciary? What is also the role of the Supreme Court? That is the focus of our episode of In Depth today. Well, the Constitution has given an arrangement of the federal government in India under which the judiciary system for union and states is not separate. It is uniform for the entire country. The Supreme Court is the highest and final court for appeals in this entire system, under which there are high courts of states and under them are other subordinate courts. This is how all the courts of India are linked, with the Supreme Court being the highest among them.
The Supreme Court of India is the guardian of the Constitution. It is laid down in Chapter 4th under Part 5th of the Constitution. Articles 124 to 147 state the Constitution and the jurisdiction of the Supreme Court in detail. Articles 124 to 147 in Part 5th of the Constitution deal with the organization, independence, jurisdiction, powers and its procedures. The Supreme Court is the highest judicial forum and the final court of appeal under the Constitution of India. Article 124 provides the provision for the judiciary in India. Initially, the Constitution provided for a Supreme Court with a Chief Justice and 7 judges. At the same time, it gave powers to Parliament to increase the number of judges from time to time, which is why Parliament enacted Supreme Court Number of Judges Act 1956 to increase the strength of the Supreme Court. In the same year, the number of judges was increased from 7 to 10. As the work of the court increased, Parliament increased the number of judges to 13 in 1960, 17 in 1977, 26 in 1986 and 31 in 2008, which is its current strength. The Supreme Court was established on January 26, 1950, while it came into being in its present form on January 28, 1950. Its inaugural session was held at the Chambers of Princes in the Parliament House complex. It was here that the Supreme Court sat for 12 years between 1937 and 1950. In 1958, the Supreme Court moved to its present premises. Every Supreme Court judge is appointed by the President.
Supreme Court is the highest court of the country, and there is no appeal against the Supreme Court. It is said that there is no infallibility, but there is finality. In whatever Supreme Court decides, that is the final law of the land till it is changed by the Supreme Court itself. So it is the final court of appeal and final court for implementation of fundamental rights of citizens and final court for interpreting the Constitution and the laws.
The Constitution provides an unified judicial system, keeping the Supreme Court at its apex. Therefore, the Supreme Court exercises enormous powers and functions. India's Supreme Court has more power in comparison to the Supreme Court of any other country, given its nature and extent. It has extensive powers in the form of original, appellate and advisory jurisdictions. The Supreme Court controls the entire judicial system in India and occupies a very significant place as the guardian of the Constitution and custodian of the fundamental rights of the citizens. The responsibility of interpreting the Constitution rests with the Supreme Court of India. The question of law decided by the Supreme Court is binding on all other courts within the territory of India. Article 129 of the Indian Constitution deals with contempt of court. Article 131 provides that Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. It has power to settle disputes between the government and the states or between the states. As the final court of appeal of the country, it takes up appeals primarily against verdicts of the High Court of various states of the Union and other courts and tribunals. Article 137 has empowered the Supreme Court to review its own orders or judgments given earlier. The Supreme Court also enjoys the power to withdraw cases pending before a High Court or more than one High Court for disposal by itself.
The Supreme Court's importance is that it makes the fundamental rights of the people enforceable, make them living realities. That's the importance. Because the Constitution guarantees fundamental rights, but it shouldn't be on mere paper. The Supreme Court sees that those fundamental rights are enforced against anyone who violates them, maybe the central government, state government, or any other organization. And it's very important for the people because they have the remedy of going to the Supreme Court directly.
Apart from this, the Supreme Court's advisory jurisdiction has been discussed in Article 143 of the Constitution. Under this, the President may approach the Supreme Court for advice on questions of law or fact of public importance which may have arisen or are likely to rise. The Supreme Court may, after due inquiry, report to the President its opinion on such matters. Bureau Report, Rajya Sabha TV.
Well, the establishment of all courts in India, including the Supreme Court, is the legacy of the British rule in the country. Although the current Supreme Court came into effect on January 26, 1950 with the implementation of the Constitution, it was earlier known as the Federal Court of India that came into being with the Government of India Act of 1935.
Our present system of courts is the legacy of the British in India. Before this, there were two types of courts in the Mughal period, the Sardar Civil Court and the Sardar Nizam-e-Adalat, where civil and criminal cases were heard. Following the failed revolution of 1857, the courts were formed on the basis of the English justice administration system. Then the Privy Council was the Supreme Court of India, which was in England. After India's independence in 1947, a new constitution was introduced in 1950, under which the Supreme Court became the highest judicial authority.
Supreme Court, you can say, is the successor of what under the Government of India Act 1935 was called the Federal Court. The Government of India Act 1935 had provision of a Federal Court. And so Supreme Court, under the new system which was established by the Constitution, that system was of a unified judiciary from bottom to top or top to bottom. One unified judiciary to consider both the, what you may call the federal laws passed by the Union Parliament, as also laws passed by state legislatures.
The Supreme Court of India came into existence on January 26, 1950 and started functioning on January 28. Earlier, the Supreme Court was called the Federal Court of India. It worked out of the chambers of princes in Parliament House. That is where the Supreme Court was inaugurated and continued functioning for the next several years. Hiralal J. Kanya was appointed as the first Chief Justice of the Supreme Court.
Even during British rule, of course, it was in a very limited way, where a federal court. But the idea the people always had great faith and great aspiration that there should be a Supreme Court which they trusted for the enforcement of the fundamental rights. They did not trust popular assemblies and majority rule in Parliament and state legislature. The people of the faith and the judges of the Supreme Court, because they are not politically inclined, They'll enforce the values enshrined in the Constitution and protect the fundamental rights of the people.
The Supreme Court was shifted from the Parliament House premises to the existing building on Tilak Road in 1958. At the time, the total number of judges, including the Chief Justice, was 8. But over time, the burden of litigation increased and so did the number of judges. There are 15 courtrooms in the existing building of the Supreme Court. However, the speed at which the work pressure on the Supreme Court is increasing, the number of courts and judges is failing to keep up with it. Bureau Report, Rajya Sabha TV.
Well, under the judicial system of the Indian Constitution, the post of Chief Justice is supreme. The significance of this can be understood by the fact that the Chief Justice of India discharges the roles of the President if the office of President and Vice President suddenly becomes vacant in emergency situations. Apart from this, if there is a confusion about the constitutional provisions, then the only valid interpretation is the one given by the Supreme Court. Let's have a look on the qualifications mentioned in the Constitution for such an important post.
The Indian Constitution gives the power of appointing judges to the President. The President can take advice on these appointments from the Union Cabinet. For the appointment of the Chief Justice of India, the President can take advice from the judges of the Supreme Court and High Courts and other people as he deems fit. In 1993, a 9-judge Supreme Court bench ruled that a judge's seniority must be considered for appointment of the CJI and that the Chief Justice of India must be consulted for the appointment of other judges of the Supreme Court.
अभी जो स्थिति है उसमें जो सीनियर मोस्ट जज होता है सुप्रीम कोर्ट का, उसको ही मुख्य न्यायाधीश नियुक्त किया जाता है. मुख्य न्यायाधीश को जो सीनियर मोस्ट हो उसको अपॉइंट कर देते हैं राष्ट्रपति, और जजेस जो हैं उनकी सिफारिश सुप्रीम कोर्ट से आती है. कॉलेजियम वहाँ पर है, जो सीनियर मोस्ट जजेस का कॉलेजियम है, वो सिफारिश करता है और प्राय जिनको भी वो रिकमेंड करता है उनको मान लिया जाता है.
The Constitution, however, does not specify any directives for the appointment of the Chief Justice of India. The eligibility criteria for the CJI is same as that of any Supreme Court judge. Article 124(3) of the Constitution prescribes that for the appointment as a judge of the Supreme Court, a person must be a citizen of India, the person must have served as a judge of any high court for at least 5 years or been an advocate in a high court for 10 years or is in the opinion of the President a distinguished jurist. There is no minimum age criteria for appointment as a Supreme Court judge. A judge of the Supreme Court, once appointed, holds office until he completes the age of 65. Article 124(4) prescribes the conditions in which the post of CJI may fall vacant. These are retirement on completion of 65 years of age, resignation and removal through proper procedures. The grounds for removal of the CJI are proven misbehavior and incapacity.
Judges are appointed. Why? Not because of the only learning, not because of the knowledge of the law, but because of their independence and because of their courage in protecting the rights of the citizens, even if it means displeasing the executive government. That's the whole thing. They are not bothered. That's what security of tenure. Therefore, Judge of the High Court is still 62. He's there. Judge of the Supreme Court is 65, can't be removed. So he's not to worry. हमारा judgment पसंद नहीं आएगा तो मेरे को निकाल देगा. Nothing like that.
The Constitution has also underlined measures to protect the independence of Supreme Court judges, including the CJI. That is why the process of removal of the Chief Justice of India is a complex one. The wages, allowances, leave and pension of the judges is determined by the Parliament and cannot be altered unless there is a financial emergency. The additional expenditure or perks of the judges is borne by the state, but the CJI and judges are not allowed to continue practice in the courts after retirement. Bureau Report, Rajya Sabha TV.
Well, the right to appoint judges of the High Court and the Supreme Court lies with a committee of judges called the Collegium. The Chief Justice of the Supreme Court is the head of the committee and 4 other senior-most Supreme Court judges are its members. This system of Collegium has been in force in our country for over 2 decades. But what is the Collegium system and why was it needed and when did it come into existence? That's what we're going to find out.
Under the Constitution, the President has the right to appoint judges in the Supreme Court and High Courts. But the Constitution doesn't have a separate provision for the appointment of the Chief Justice of the Supreme Court. From 1951 to 1973, the Supreme Court's senior-most judge has always been appointed as the Chief Justice of India. According to the Constitution, the President, under the advice of ministers, can also consult judges of the Supreme Court and the High Court. To understand the current debate revolving around the appointment of judges, we need to go back to 1973, when Justice A.N. Ray was appointed as the Chief Justice of India. His appointment superseded 3 senior judges of the Supreme Court, Jaishankar Manilal Shelat, A.N. Grover and K.S. Hegde. This triggered widespread protest by bar associations and legal groups across India. It was believed that the other senior judges were not considered for appointment as their judgment in the Keshav Nanda case was not in favor of the government. Not only this, in 1977, Justice H.R. Khanna was replaced by Justice M.U. Baig as the Chief Justice of India. In protest, Justice Khanna also tendered his resignation. Legislators and judges who criticized the government's move felt that the judiciary's discretionary powers were reduced. This led to the establishment of the Supreme Court's Collegium system that appoints judges to the nation's constitutional courts. The genesis of the Collegium system is in 3 of Supreme Court judgments that are collectively known as the 3 judges' cases. The first judge's case is the S.P. Gupta case in 1981. In this case, Supreme Court consultation was taken only as consideration in the appointment of judges. In 1993, a bench of 9 Supreme Court judges, led by Justice J.S. Verma, reversed this arrangement and considered complying with the Supreme Court's advice to be binding. The court said the Collegium will do the transfer and appointment of judges. This decision came to be known as the second judge case. The introduction of the Collegium system actually started with this case. In 1998, then President K.R. Narayanan sought the opinion of the Supreme Court on the meaning of the word consultation under Article 124, 217 and 222 of the Constitution. A few days later, a 9-member bench of the Supreme Court, headed by Justice S.P. Baruch, ordered on October 28, 1998, that in the matter of appointment of the governor is above the legislature. The Supreme Court's verdict in 1993 was thereby right to say that the consultation was binding. This order is known as the third judge case. Under the Collegium system, a committee of senior judges, headed by the Chief Justice of the Supreme Court, decides on the appointment of judges. The Collegium comprises the Chief Justice of India and 4 senior-most judges of the Supreme Court. Other than appointment of judges of the Supreme Court and High Courts, the Collegium also decides on the transfer of judges. The Collegium also takes decision on promoting High Court judges to Supreme Court.
Collegium consists of the 5 senior-most judges of the Supreme Court, and they consider all proposals for appointment to High Courts and Supreme Court, which means that the senior-most judges, they sit together and they decide proposals for appointment of High Court and Supreme Court judges and send the names to the government, and the government is supposed to send them to the President, and then the President appoints. So strictly technically the appointing authority is the President.
Besides this, the Supreme Court has also laid down 9 guidelines for the functioning of the Collegium system. Bureau Report, Rajya Sabha TV.
Well, although the country has been for long debating the Collegium system for appointment and transfer of judges, there are allegations there is a possibility of favoritism in this arrangement. Amid this debate, the government initiated the formation of the National Judicial Appointments Commission as an alternate arrangement for the appointment of judges before the Supreme Court struck it down. Let's take a look at how this came about. The judiciary is no stranger to allegations of nepotism. Members of quite a few judicial and political families have found a place in higher judicial posts. Some judges have also faced allegations of lobbying for their children for a place on the bench. The media has also reported several instances of judges lobbying with the Supreme Court for appointments to several high courts for their sons, daughters and relatives.
Earlier system, as I said, actually it was the executive who was making the appointments, really speaking, by and large. Mainly in consultation. But the executive had the last word. The executive does not have the last word. It has a voice, but not a veto. It cannot dictate. It can tell the Collegium that, look, this particular judge or particular person you want to elevate, these are the things about him.
Which is why there is long pending demand for transparency in the appointment of judges. The Constitution 121st Amendment Bill of 2014 was introduced in the Lok Sabha on August 11, 2014 by Minister of Law and Justice Ravi Shankar Prasad. The bill was cleared by both houses of Parliament, and on 31st December 2014, the then President Pranab Mukherjee gave his assent to the bill. The assent came after 16 state legislatures out of the 29 states ratified the bill. The bill amends Article 124(2) of the Constitution to provide for a commission to be known as the National Judicial Appointments Commission that would have replaced the Collegium system for the appointment of judges. However, on the 16th of October 2015, the Constitution bench of the Supreme Court upheld the Collegium system by a 4:1 majority and struck down the NJAC as unconstitutional.
मौजूदा स्थिति तो यही है कि सुप्रीम कोर्ट, हाई कोर्ट के जजेस और सुप्रीम कोर्ट के जजेस, उनके बारे में जो सुप्रीम कोर्ट के जजेस का कॉलेजियम है वो ही फाइनल निर्णय करे, ऐसा सुप्रीम कोर्ट का कहना है। और जुडिशल सर्विस की बात की जाती है, ऑल इंडिया जुडिशल सर्विस की, लेकिन वो भी अभी हुई नहीं है। वो प्रस्ताव उसके समय समय पर आते रहते हैं, लेकिन वो अभी हुई नहीं है।
As per the amended provisions of the Constitution, the NJAC would have consisted of the following 6 people. The Chief Justice of India as the chairperson, 2 other senior judges of the Supreme Court, the Union Minister of Law and Justice, 2 eminent persons to be nominated by a committee consisting of the Chief Justice of India, Prime Minister of India and the leader of the opposition in the Lok Sabha, with one of the 2 eminent persons from the scheduled castes or scheduled tribes or OBC or minority communities or a woman.
And as I told you, I'm repeating myself, the Supreme Court Collegium may consider it. After considering, they may accept it, they may not accept it. If they don't accept it, their word is final and the appointment must go on. Appointment of a judge or elevation of a judge of the High Court to the Supreme Court.
As per the amended Constitution, the functions of the NJAC would have included recommending persons for appointment as Chief Justice of India as well as Chief Justices of High Courts and other judges of the Supreme Court and High Courts. It was also to be entrusted with recommending transfer of Chief Justices and other judges of High Courts from one High Court to any other High Court. It was also to ensure that the persons recommended are of ability, merit and other criteria mentioned in the regulations related to the Act. Bureau Report, Rajya Sabha Television. Well, that's it on this edition of In Depth, but we'll be back same time again tomorrow with a brand new edition. That's it from me. See you again next time.